Hello, my name is Tom Squier. I am an estate planning attorney in Puyallup, Washington. Many of my clients know the various documents that go into a good estate plan, but even when they know the names of those documents, they don't necessarily know what each document does and the difference between them. So today I just want to talk a bit about a couple of those documents so you can know a bit more about them. Today specifically, I'm going to be talking about advance directives, living wills, or healthcare directives, all of which are just about interchangeable terms, but there are some slight differences that I want to just talk about today. These kinds of documents are used to address end-of-life decisions and can be used more broadly for any healthcare decision, but it's usually going to be end-of-life decisions, talking about when there should or shouldn't be life support. So the broadest term here is advance directive. An advance directive can be any set of instructions given ahead of time saying what should happen in certain medical situations. So a typical scenario for this would be that a client writes out an advance directive saying that if I am terminally ill or if I am permanently unconscious, I don't want to have life support anymore. Now, I think the term advanced directive is a bit too broad because it can cover all sorts of things beyond that. So I like to hone in a little bit on more specific terms, and that could be living will or healthcare directive. I like to use the term healthcare directive because living will or healthcare directive, they're just about interchangeable. There's not really much difference between them. But a living will, oftentimes that gets confused with a will, a last will and testament. A living will, on the other hand, it's just like a healthcare directive. You're going to be saying what should happen in pretty serious end of life situations. So, what I described before is pretty much the typical scenario. You're going to outline in the healthcare directive if you are essentially in the process of dying, you're on life support, and there's not hope of recovery, then most people say they want to be taken off of life support. But in many cases, they want to have pain medication maintained during that process to keep them comfortable. So that's a very typical healthcare directive. And you can customize these just about any way you'd like. Even though that's the most typical scenario I see, you could add all sorts of stuff to address any healthcare situation that might be important to you to address in advance. So a healthcare directive is related to a healthcare power of attorney. The big difference between a healthcare directive and the healthcare durable power of attorney is that in that power of attorney, all you're doing is you are naming the agent. The agent is going to be the person who decides everything that you haven't decided already. The healthcare directive, you make decisions about what should happen in scenarios that you've thought about in advance. The healthcare power of attorney is then used to say, this is the person who will make all the other decisions that I didn't think about or didn't know what to do in advance. So the last thing that I want to talk about today are do not resuscitate orders, or DNRs. And these are pretty closely related to healthcare directives, and you could even, in theory, call it an advanced directive because it fits that general definition of instructions that you make in advance relating to healthcare. But a DNR is a little bit different because it's going to be signed by your doctor as well as you, or a healthcare provider that you regularly see. And it is not going to be just about when to remove life support, which is usually the idea behind a healthcare directive. A DNR, on the other hand, it is saying that you never want to be put on life support in the first place. It's going to say that if you are not breathing, if your heart isn't beating, that you don't want them to attempt CPR, that you don't want them to attempt any other life-saving measures. And DNRs, of course, like any other document, can be modified so that they can have different ranges. But most people, when they're filling out a DNR, it's to say that they don't want the attempt made at all if it looks like there's no hope of recovery. A DNR, a very common form, is called a physician's order for life-sustaining treatment or a PULSed form. You may have seen these at your doctor's office. It would be a bright green form. And when you fill one of those out, you take it home after it's signed by you and the doctor. You post it somewhere the paramedics would see it, oftentimes the refrigerator. And that way they know that if they come out there for an emergency call, they can look at that PULSed form and see exactly what you want them to do. So you may not even make it to the hospital depending on how you fill it out, because you may say you don't want them to take you, that you don't want them to try. So that's pretty much it. I want to just go over healthcare directives, advanced directives. The easiest way to think about it is a healthcare directive is a document that says when you want to be taken off of life support. So next time I'm going to talk a little bit about the differences between a last will and testament and a revocable living trust. So next time it's the really big main estate planning documents. I hope you all have a wonderful day and take care.